So, good morning, everyone. I'm going to start us because we have a very long day, and I want to have us to see if we can keep on time and get everything working on time. Welcome. This is our conference on Deregulatory Frontiers. We have a very exciting set of panels, and I'd like to introduce our academic dean, Professor Maurice Ratner, to open and welcome everybody to Hastings. Thank you, Maurice.
Thank you. Good morning, welcome. In Trump's October 22nd, 2016 contract with the American voter, he pledged that for every federal regulation, 2 existing regulations had to be eliminated. Shortly after taking office, President Trump signed Executive Order 13771 that aimed to put this policy into effect. The order also said that the cost of any new regulation should be offset by eliminating equally costly regulations. Was this just a theatrical gesture, part of an ongoing spectacle for a certain segment of the voting population, or are we truly in a deregulatory environment? And if so, what are the consequences? Specifically in the domains of environmental protection, public health, and financial regulation. Our distinguished panelists today come together from a broad cross-section of academic and practice specialties to explore these and other questions. I would like to thank the conference organizers, UC Hastings faculty Dorit Rice, Jamie King, John Crawford, Abe Cable, Dave Owen, David Takash, Zach Price, and Sarah Hooper. I also want to extend our thanks to our moderators and panelists, Faculty Events Manager Roz Foy, and UC Hastings Consortium on Law, Science, and Health Policy Fellow Laura Hagan for their help organizing the event, Abigail Blue for her help managing the budget, UC Hastings for sponsoring and hosting the conference, the consortium for supporting it, and the Institute for Health Policy Studies at UCSF for media sponsorship. It is now my pleasure to introduce Professor Zach Price, who will make more substantive opening remarks. Professor Price is a rising star in constitutional law scholarly circles. Before entering academia, he served as an attorney in the Office of Legal Counsel of the U.S. Justice Department. He also clerked for 3 judges, including Justice Anthony Kennedy of the United States Supreme Court. Zach Price.
Okay, well, thanks very much, Morris, for the introduction, and thanks to all of you for being here. I'm really excited about this conference, looking forward to learning a great deal from the presentations over the course of the day. So it's a real honor to get to start things off. And so I think my job is to help set the stage for the more topic-specific discussion over the course of the day. And so what I plan to do is sketch some key features of the political context of current administrative governance at the federal level that I think bear on some of the deregulatory questions we'll be exploring over the course of the day. And then I want to briefly highlight several important and I think underappreciated, potentially threatened legal constraints that might be doing some significant work in constraining troubling forms of deregulatory action or administrative action more generally. So let me start with the political context. So President Trump, of course, is a deregulatory president, as our flyer suggests, right? And it's something he's quite proud of. In fact, he's the best ever, apparently, right? He says not even close. But what does it mean to be a deregulatory president? I think the best way to think about it is to say that his administration has acted in various ways to reduce effective legal restraints on private activity, reduce federal legal burdens on private enterprise, other types of private activity. So framed that way, what he's doing is not anything particularly new. It's frankly what we expect from Republican administrations at this point. And overall, the Trump administration is employing a pretty standard playbook, going back at least to Ronald Reagan, who in many ways is the kind of paradigmatic deregulatory president of the modern era. So he's seeking statutory changes where possible, trying to repeal substantive regulations where possible, but then more generally trying to paralyze agencies' enforcement capacity by cutting their budgets, pointing heads with limited enthusiasm for their agencies' regulatory missions, or even outright hostility to them. So again, this is not anything particularly new in the context of past Republican administrations. To my mind, what might be more surprising is that President Obama was also in some ways a fairly aggressively deregulatory president. He's not normally described that way, but I think that in itself is a function of politics, right? For Obama supporters, deregulation is a sort of dirty word, right? It's not something they'd want to attribute to him. And of course, he was quite aggressively regulatory in certain areas like climate change and so forth. On the other hand, people who generally think of themselves as supporting deregulation don't have much interest in complimenting Obama. But at least two of his signature initiatives, his immigration programs, DACA and DAPA, and his marijuana enforcement policy were effectively deregulatory actions. They aim to strip force from existing statutes, change on-the-ground realities without any change in the underlying substantive statutory restrictions. And they're pretty dramatic in their effects. I mean, you wouldn't have to go too far outside this building to find what is notionally quite serious narcotics conspiracy operating quite openly as a function of enforcement practices he set in place. DACA also has enabled close to 1 million people to participate more openly in American society. DAPA, had it not been blocked, would have been even more dramatic in its effects. So those are ways in which Obama, I think, meets that definition of deregulatory that I offered earlier. And then describing him that way, I think, highlights ways in which characterizing Trump as deregulatory also isn't quite right either. The Trump administration favors strong government restraints in certain areas, on some forms of private conduct, just in areas of social regulation like immigration, drug policy, rather than private business enterprise. So this is also not particularly new to see this basic mix of issues on the two sides. But I do think seeing two presidents who are different in so many ways, both using their power fairly aggressively in this fashion, in particular seeing a Democratic president doing this, might suggest some structural explanation going beyond the particular personalities involved. Or at the very least, their actions might reflect some long-term trends that have been developing for some time and are likely to continue in the future. So what do I have in mind? I think the key development, or at least the one I want to highlight, is the increasing polarization of our political life. So there are a lot of ways to capture this, lots of evidence of this, but just as one example, here are results across in recent years from the Pew Research Center. Voters are now further divided on key liberal conservative issues than they've ever been before in the history of this poll, a trend that's quite evident across recent decades. And perhaps more significantly, the same sort of trend is even more evident in congressional voting behavior. These are graphs that track the degree of polarization in the House and Senate over time, using a measure political scientists have developed that basically tracks the degree to which folks of one party are voting consistently with each other and against the opposing party. So from that point of view, you can see we've been on a very steep ascent at the highest levels now since Reconstruction. Following several decades ago, the level of polarization was much lower in Congress. So we've got increasing polarization in the public, reflected in congressional voting behavior. And then a last piece of the puzzle, a bit more speculative, but there's also some evidence that at least recently, the key fault lines of the political environment are shifting also. So the electorate seems to be, this is a plot of, based on voter surveys from the 2016 electorate that splits apart liberal and conservative axes along social and cultural issues and identity issues versus general economic questions. And so suggests here that the more pronounced split is more along the social cultural dimension rather than the economic dimension. And of course, the key story of the 2016 election is the Republican Party picking up more voters who were economically liberal but socially more conservative. So these are important background features of the political environment. We've got increasing polarization in Congress, possibly a shift in the terms of the key fault lines. So how does this relate to our topic? How is it relevant to administrative law? I think this political picture provides some important context for the sort of high-profile administrative disputes. Might suggest that the sort of aggressive administrative action is likely to remain a key feature of federal governance. So why? So I think it has a couple of effects, and this is not anything particularly novel, drawing here mostly off political science commentary that makes sense to me. But I think one key feature, particularly of this picture, is a reduced overall legislative capacity in Congress. With such high degree of negative partisanship, opposition party has very little incentive to help the majority party deliver on campaign promises, particularly to help a president from the opposing party. So that means passing any significant legislation is going to be relatively more difficult. There's a particular problem in periods of divided government, but I think you could say we see now how this creates challenges even when your party controls the majority. So we've got limited legislative capacity in Congress, but then to the extent Congress can't deliver on electoral promises, pressure probably increases on the president to try and do so unilaterally. That's at least one way to explain what Obama was doing with immigration, probably also the story of Trump's approach to the Affordable Care Act. So you've got limited legislative capacity, greater pressure on the president to deliver on political promises. And at the same time, though, overturning executive actions through legislation is going to be even more difficult. If it's hard getting a majority in a polarized Congress, it's going to be even harder to get to veto-proof majority. So that gives the president broader political space in which to operate without congressional restraint. And then finally, I think there's some reason to think that this environment might also drive presidents to take more extreme positions. So presidents reflect a national constituency, but they're delivered to the White House by a particular partisan coalition. And so there's evidence they appear to target policies not only at swing voters they need to get on their side, but also at key constituencies, core elements within their party. And so that means that a successful campaign requires persuading some centrist voters, but also that elections increasingly turn on relative turnout and enthusiasm, as opposed to the appeal to the median voter, who's increasingly lonely on the political spectrum. So at any rate, Trump seems to have got himself elected with this strategy, and seems to be governing on the assumption that it can work. Also, as an aside, I think that these problems could have even worse effects, right? Polarization may also create strong incentives for selectivity in enforcement, allocation of benefits on partisan and geographic grounds. That's the sort of problem I think we're starting to see reflected in policy and I might see more of in the future. Then the last point I think is that all these problems are probably compounded if it's true that the fault lines of political conflict are becoming more centered on questions of identity, sociocultural attitudes, because then, rather than economic division, because then voter preferences might be that much more locked in, more impervious to persuasion. So for all these reasons, I think the administrative aggressiveness, particularly those policies I highlighted from the Obama and Trump administrations, reflects some deeper trends that preceded them, are likely to continue. We have a divided, polarized electorate, which appears to weaken Congress's legislative capacity, thus putting greater pressure on the president to deliver policy changes, which Congress then may have difficulty overriding. At the same time, executive officials might have incentives to aim their policies at the base rather than the increasingly non-existent centrist voters. So this all, I think, has really important implications for administrative law in general, for how our constitutional structure operates. I think a last point that's relevant here is the way it plays also into broader public perceptions and debates. Given the current high levels of negative partisanship, almost everyone in the country at this point is what one might call a situational legalist, including commentators, opinion leaders, people other regular folks look to for guidance. People care about the niceties of procedure, legality, interbranch roles when it suits their substantive preferences, but not so much when their side is winning. And I think that means that even beyond the problem of congressional constraint that I was describing earlier, there's likely a weakened political constraint on aggressive or even illegal executive action. But I think if political constraints are in fact weakening on administrative aggressiveness, then identifying key legal limitations on executive policy that might be sustainable in this environment may be particularly important. And so in that spirit, I want to use the rest of my time to just highlight briefly three legal limits that seem to me to be underappreciated, possibly threatened sources of moderation, restraint in this environment I'm describing that could be applied symmetrically across administrations. And the three I have in mind are, first of all, the president's obligation to act through subordinate officers, and then his inability to undo either statutes or regulations at will, and then finally, the principle that non-binding informal policies generally can be abrogated at will by a succeeding administration. So, first point, obligation to act in most instances through subordinate officers. So this is partly just a practical reality for presidents. The president's just one person, can only do so much. But as administrative law scholars here know, there's a background legal question, long-running debate over the unitary executive branch, the degree to which the president can personally exercise authorities vested elsewhere in the executive branch. It seems to be that the view that has prevailed in practice and is also correct is that Congress can vest particular authorities in particular offices, and then in that case, only those officers, not the president himself, can exercise those powers. The president may then be able to fire the officer for disobedience, but he can't just perform the function himself or direct someone else to do it willy-nilly, has to act through the subordinate office. And so Trump, despite periodic eruptions of frustration with his subordinates and with this principle in general, seems to me to have respected it in practice. And I think that it has a couple important implications. For one thing, it makes the Senate confirmation process a more meaningful limitation on government policy. But more importantly, I think it actually enables power to flow towards the White House or away from it according to political exigencies. So under normal circumstances, cabinet secretaries don't need to be told twice to do something the president wants. They're part of the team and want the administration to be successful. But if, just hypothetically, you have an erratic, unpopular, ineffective chief executive, a turbulent White House, then office holders are likely to have more room to set policy independently from the president, might be more responsive to overseers in Congress and other influencers, other influences instead. I think at present that pretty clearly describes the way that at least the Defense Department is operating. I think the Justice Department to some degree also, probably other agencies. And I think that's an important feature of this design to enable that's those sort of political dynamics to come into play. I also think this structure enables an important mechanism of broader norm enforcement. This is what I might refer to as the fire alarm function of office holding, right? So if a president directs an officer to do something they consider illegal or profoundly unwise, they can quit, they can force him to fire them, but then the action won't happen until the president finds someone else who will carry out that function. That's what happened in the Saturday Night Massacre. There are other historical examples. I think as a practical matter, that's what's protecting the Mueller investigation right now, the fact that Trump would have to fire Mueller by firing someone else. And the effect of this is it enables lower level officials to raise the salience, set off alarm bells when they think something really wrong is happening, potentially penetrate that fog of biased commentary that tends to shape public opinion. So I think these are two important benefits of this structure, the ability to set off that sort of alarm and the ability to redistribute power according to political exigencies. But they only work as long as we maintain this legal understanding that it's the officers and not the president himself who exercises the underlying statutory authorities. So that's a first important legal limit on the president that I think is important in this environment. A second one, more briefly, relates to the process for removing statutes and regulations, more at the core of deregulation as opposed to affirmative regulation. So under the view I take to be pretty settled at present, repealing a statute generally requires another statute. Repealing a regulation, a notice and comment substantive rule, requires another regulation, another notice and comment process. So that means presidents and their subordinates can't just repeal statutes and regulations because they don't like them. They have to use the prescribed process at the appropriate level of formality. With respect to regulations, this principle actually has an interesting history that I think is worth just kind of anecdotally flagging. I can't resist retelling briefly. Early in the Reagan administration, folks actually pushed hard for the opposite view. They argued on basically libertarian grounds that deregulatory action should be procedurally unconstrained because it was returning people to kind of natural liberty baseline rather than imposing affirmative constraints. Our colleague here, actually, Rule Schiller, has a great essay going through the history of this and other related arguments and the way they actually end up losing in court, often at the hands of conservative judges. But while the issue was a live question, it implicated two personalities who've come back recently. One was then Professor Antonin Scalia, who, while the State Farm case was administrative law people know and love from this period, involved deregulation of seatbelt requirements. Scalia had this, most people think it was him, this anonymous essay about active judges and passive restraints, urging precisely this libertarian theory. One of his key opponents was whippersnapper named Merrick Garland, who was one of the lawyers in the State Farm case, wrote an important article about deregulation and judicial review later on. Of course, years later, President Obama nominated Merrick Garland for Scalia's own seat. Although Garland prevailed on the legal question at the time, maybe Scalia had, we all know how this turns out. But in any event, I think this principle, one reason to flag all this background is I think this principle and the related principle about repeal of statutes seems to me to be correct and has been an important source of legal stability in a turbulent environment. And part of the reason for that is if an executive action pushes past these particular limits, it's pretty easy for a court to correct. It can simply overturn the removal, the suspension of the statute or regulation, restore the underlying substantive restriction. The Trump administration, a sort of echo of the Reagan view, has in fact tried to suspend a number of regulations, including important environmental protections, the fugitive emissions rule, for example, for methane. But in courts, without going through the notice and comment process, and courts have just overturned those suspensions, restored the underlying regulation. I think this is more controversial. I think it's also the right way to understand what the Fifth Circuit was doing with DAPA, preventing that program from taking effect during the Obama administration. So all those decisions illustrate the way they serve to keep laws in place despite an administration's hostility to them. And I think that's proved to be an important break on deregulatory action. That brings me, though, to my last point, a last restraint, possibly the most controversial point, which is what about more informal policies, non-binding internal guidance documents, and so forth. So I think one consequence of preventing unilateral repeal of statutes or regulations is to channel deregulatory political pressures instead into putatively non-binding internal policies and practices. So this is the story, even apart from all the regulatory repeals, of a lot of what the Trump administration is doing. particularly with respect to the Affordable Care Act. I think it's also the story of Obama's marijuana policies, if not the immigration initiatives, depending on how you view those. And this type of action presents some really tricky problems, particularly for judicial review. In my own view, which I've argued elsewhere, I think executive officials should understand themselves to be duty-bound to enforce the laws they administer. But courts have a lot of trouble enforcing that obligation. So I've also suggested you should think of it as a kind of political question in the sense of the political question doctrine. It's a principle that an obligation that executive officials have, but the courts imperfectly enforce. It's very hard for a court to identify neutral principles governing what priorities an administration should adopt, or even whether it's making sufficient effort at all. But for that reason, I think what's left instead is another essential limitation, which is that this type of policy is revocable. A future administration, even the same one if it wants, can reverse the policy, resume enforcement of the substantive legal requirements, even as the conduct that took place while the permissive policy was in effect. And so this, particularly in this polarized sort of seesaw environment, sets up a real risk of unfairness, even cruelty. I think you see that playing out now with immigration and to a lesser degree marijuana. Effectively, what it does is it lets one administration sort of play chicken with the next administration, allow practical reliance interests to build up around a given policy in hopes that those political restraints will prevent its reversal down the road. But I think in general, the law can't protect that sort of reliance, because doing so would eliminate the central limitation on this sort of policy, which is that administrators can't eliminate statutes or regulations simply by promising not to enforce them. So I highlight this point in closing because an emerging theme in a number of the anti-Trump lawsuits is to resist this principle, to argue on various grounds that various Obama-era policies can't now be undone for one reason or another. The key example is some of the DACA lawsuits that make this argument squarely, but it also pops up in various ways in cases involving ACA subsidies, the transgender military policy, some environmental questions that at least are coming down the road, if not present right now. And these cases often, I should say, involve extremely sympathetic litigants. They involve a number of other questions. I think they each have to be evaluated independently. They involve equal protection questions in many cases, for example. But I think this is an area where courts need to tread very carefully. If Trump's critics' worst fears about him are correct, then before his administration is done, there might be quite a lot of lawlessness with little immediate consequence. Not only in the areas of administrative regulation we're going to be talking about over the course of the day, but quite also gun control, ethics compliance, Affordable Care Act, campaign finance, any number of other areas. And courts need to be careful not to set precedents in these areas that could complicate vindicating important substantive laws down the road. So to sum up, I think there are some deep political dynamics driving the sorts of controversial deregulatory action we've now seen across two administrations. And a key challenge for administrative law, I think, is to identify legal limits that can potentially moderate those dynamics. And so in that spirit, I've tried to highlight three: the president's dependence on subordinate officers, his inability to change substantive legal restraints unilaterally, and his inability to freeze in place permissive policies that a successor might wish to overturn. But with that, I'll stop there. Look forward to your questions, reactions, and to hearing more from all of you over the course of the day. So thanks very much. So we have a decent amount of time. I didn't succeed in filibustering adequately, but so if people happy to take questions or start dialogue, yeah. So this is a great question. I am not, the question was why is polarization happening? I mean, so political scientists have been trying to figure this out. I mean, one theory is that it's largely a function of economic inequality. some people think immigration may be a factor, but then it also seems to be happening now in places where neither of those two things are particularly true, like Poland, for example. And so it may also have something to do with the internet, I think might be part of the current environment that matters, the way in which disrupting mediating influences is allowing people to live in their own filter bubbles and be more prone to negative partisanship. So I'm not sure I can competently answer that, but I know that those are all things that people are pointed to, and a lot of people are trying to figure this out. Yep.
For the non-lawyers in the room, can you take us through, with respect to the point about the president's requirement or obligation or responsibility to act through subordinates, can you take us through the strongest arguments that you see on that unitary executive side, on both views in terms of across the spectrum, in terms of how the thinking and how the arguments are organized at this point in terms of thinking about that?
Yeah, so the unitary executive branch view has been associated with, it's generally a conservative position. The Reagan administration Justice Department was a big proponent. And the basic theory of the unitary executive branch is, we have a legislative branch, we have an executive branch. The president is the head of the executive branch. The first clause in Article 2, the so-called vesting clause, gives him executive power. He's also obligated to take care that the laws are faithfully executed. And so the theory is that Congress may set up subordinate offices, but all executive power is necessarily held by the president personally, even if he can't practically exercise it himself. Then there are a range of views from there. The question that's been most litigated and perhaps the biggest source of controversy is then to what degree can Congress impose removal restrictions on subordinate officers, have independent agencies, tenure protections that limit the president's ability to fire those people. So unitary executive branch view might suggest that that's unconstitutional. So then there's a kind of intermediate position, sort of where one might think that removal is always possible, but it's still it's not the case that the view I was suggesting is it's still not the case, even if removal is constitutionally required, that the president personally holds the authority. The vesting clause doesn't carry that implication. Congress has authority to create offices under the necessary and proper clause, can vest them with particular authorities, and so he may be able to get his way, but removal is the only way of doing that. And so that sets up the sort of constraints I was talking about. I think whatever you think about the possibility of tenure protection. Now, this also intersects with a question about what's called presidential administration, which is a particular governance style sometimes associated with the Reagan, in some ways, spearheaded, that's also sometimes associated with the unitary executive branch view, although non-unitarians like Obama have also practiced it quite aggressively. And that's the idea that notwithstanding the distribution of powers throughout the government, the president tries to centralize effective policymaking control through regulatory review, through executive orders, through publicity surrounding various policies to kind of make the president more centrally controlling what happens throughout the executive branch. And so that is a style that's taken hold in most presidents' practice. So part of the point I was trying to make earlier is Trump sort of notionally is a pretty aggressive presidential I don't know what to call it, practitioner of presidential administration, but I actually think he's quite ineffective at it. I think that in practice, he doesn't always, he's not having the sort of fine-grained control that, for example, Obama had over what was happening throughout the administration. And I think presidential administration has a number of problems. I'd sort of like to see that be a more durable shift, if I'm right, that's happening, but I think it's probably something that's going to snap back and forth, but that could have benefits too in the way I was suggesting earlier. Yeah.
So I appreciated your comments, and I think one of you've alluded to this, I'm going to ask you to maybe elaborate, is do you see the critics, say Trump's critics in particular, there's been sort of like this idea of reinvigorating the take care clause to try to get the administration not to undermine existing statutes, like for example, the ACA or other things, to actually carry out the law as written. And do you see any indication that courts are potentially more receptive to this broadening notion of the take care clause being a basis to challenge presidential inaction? And if that's the case, do you think it's a good thing? Or is that what you were alluding to earlier when you said we should be careful, or courts should be careful of reacting to the moment as opposed to thinking more broadly about what sort of precedent we want to set?
Yeah, so great question. So I think it's kind of context dependent. So I do think that take care clause is an important piece of the Constitution. I think it creates that obligation to carry out statutory obligations that I was mentioning earlier. So I actually argued back in the Obama days, I thought that DACA violated that principle because it was so categorical and excluding people from the scope of a statute and doing so on a kind of prospective basis. But I think the trouble is that that's a sort of limit that courts can manage. So if Trump were to say, and there are other cases going back earlier with environmental programs, the Bush administration, you could envision Trump doing something like that in other contexts, or like the methane rule suspension, where then the court just says, you can't change the law, you can't provide this degree of guarantees, so we're just going to return to baseline. The problem that courts where they run into is, what if it's not that? What if it's just kind of more generic inaction, right? Like we're just not bringing any enforcement cases, or we're not, we're very, or we're, that sort of torpor, right? That's the sort of thing where I think courts rightly are reluctant to invalidate, because then the remedy would then involve the court sort of taking over the basic administrative function, and would involve drawing a lot of lines that are basically policy choices about how, what to focus on and how far to go. So I think there's not a good judicial solution to that sort of thing. I think the most important legal limit is the one I closed with, that people are still at risk, right? So so there's this DC Circuit case over the methane rule, and the court says you can't just suspend a regulation, you have to go through the notice and comment process and all that. And so you might think, well, obviously they're not going to enforce it. I'm still okay. But I think if you're a company, is that a risk you really want to take? So I think that's the key limit on that type of just enforcement torpor. And so I think courts do need to maintain that, but it's sort of indirect effect. Yep. Sure, I can try. So I think executive orders, so actually during the Obama years, the term got used very loosely. Like DACA was described as an executive order when it actually was an action by the Department of Homeland Security for which the president took credit, which is a great example of presidential administration, the president kind of controlling, taking credit over things other agencies are doing. An executive order per se is a particular type of legal directive that the president issues pursuant to specifically presidential authorities. And so another feature of presidential administration is to use executive orders to say, hey, DHS, adopt a rule doing this or that, or reconsider this rule, or that sort of thing. But Trump has respected that formality, the distinction between himself and offices, by generally framing them that way, saying you should consider adopting a rule with these features, or you should directing people to undertake certain rulemaking, which leaves it up to them ultimately to decide at the end of the day on what the regulation says. So, for example, we had a big Affordable Care Act executive order that got a lot of attention recently, but actually didn't change the law itself. It just directed HHS to make changes within certain parameters. Regulatory review then is this process that the Reagan administration set up with some antecedents based on a fairly aggressive interpretation of the Paperwork Reduction Act, where regulations have to go through this office within the Office of Management and Budget, part of the White House, for cost-benefit analysis before they get finally promulgated, and presidents have used that as another technique for limiting, controlling regulatory output. Hopefully that was all right. Yeah. Yeah.
I'm not really trained in law, but it does seem like Trump is kind of messing the legislative branch, or both the FBI is trying to push the, investigation of Hillary, which there have already been like 4 dozen, I guess, or whatever.
Yeah.
And just some of these things, I mean, nobody goes after their running mates or their, competitors in the presidential race. I mean, but nobody seems to stop them. I mean, can Congress stop it? I mean, I guess if anybody tries it, he goes on Twitter and calls them names and, everything else. I mean, I guess he doesn't seem to be behaving as if there is separation of powers. I mean, maybe he sort of is, but he whines about it and, tries to be pushy. And I don't think he appreciates the separation as much as you're giving him credit for.
Yeah, no, I mean, Trump, so there are a number of things that are novel about Trump. One of them, I think, is just a even stylistic unconcern with the whole notion of legal compliance. I mean, normally presidents push the envelope, but, have go through, paper it over in ways that they hope will be convincing. And Trump, a great example of this, he recently apparently had this meeting with a group of tribal leaders, and the question of resource extraction came up and various regulatory constraints. And he apparently, reportedly, just sort of said, just take it out of the ground. It's a new regulation, like we're a new administration. We don't care about this sort of thing, so just do it. And people sort of looked at him in a kind of flummoxed way. I think he's still operating in an environment where that, people aren't necessarily going to take him up on that sort of thing, but it's certainly a danger that could happen. And so that's, again, part of the reason why I think the notion that the president can't just allow things that break the law, his permission doesn't change the underlying law, is a really important limit on executive authority. Going beyond that, in terms of what Congress can do, a key feature, what enables administrative law in the first place, is that now we're in an environment where we have a lot of laws in place that delegate a lot of authority to executive agencies, give them a lot of effective power of policy initiative. And so in some ways, Congress's more important powers are not so much the kind of textbook, pass a bill, change the law sort of thing, but some of its other tools. I think one of the most important ones that I've actually written about recently, I think, is the appropriations power is a key constraint. The president does have to keep coming back for Congress for money. We have the practice of annual appropriations, which means every year there's an opportunity for Congress to influence executive policy, stop certain efforts if it wants. Powers of oversight and investigation can also be politically significant. But the last thing, just in response to your question, I think that pointing out the Hillary Clinton FBI stuff highlights the point I alluded to about selective prosecution starting to become a real risk in this environment of polarization. And the way I think about this is that many of the people who are appalled by the idea that Hillary Clinton would be investigated, and is generally presented as like, this is something banana republics investigate their political opponents. We don't do that. But many of the people who think that would also be quite happy to see people in this administration end up in prison. And I think there's a difference there. And maybe this is my own perspective. It seems to me there's clearly a difference in the level of justification. But the problem with selective prosecution is we've kind of been getting by on prosecutorial discretion, making relatively neutral judgments about when a case is important enough to warrant prosecution. And if we get an environment where people kind of are demonizing their opponents to the level where they'd like to see them in prison, that's going to come under a lot of stress and is going to be another problem I think courts and commentators are going to have to grapple with. Okay, yeah.
While I'm troubled by the universal or unitary executive theory, I remember something that went mainstream during the W administration with that theory, and it's just signing statements. And I wonder if those have continued to be something that this administration has used, since it seems to accentuate that theory.
Yes, so a signing statement is a statement the president issues when signing a new bill into law, and they can be totally uncontroversial, like, what a great law I just signed, thank you, Congress, sort of thing. But where they're controversial is presidents have a practice of sometimes highlighting provisions that they view as unconstitutional and saying, I'm going to treat this as precatory or that sort of thing. So I think this is a sound practice in general. So one feature of the take care responsibility is that the president has a kind of a obligation of the Constitution as well as the statute within the hierarchy of legal authority. And so presidents, going back at least to Thomas Jefferson, have sometimes claimed authority not to implement or enforce a law based on an independent judgment about its constitutionality. The trouble is, of course, that which relates to a broader question about executive power, is that presidents have a strong incentive to be self-serving in their view of their own authorities. Trump has, no, he's had at least one, probably others, but he has taken some fairly aggressive positions. One I'm aware of, just because it relates to the appropriation question you're talking about, is he actually claimed authority. Right now, Congress has a recurrent appropriations rider preventing federal enforcement against state-authorized medical marijuana providers. So Obama put the enforcement policy in place, but since then, Congress has partially codified it as a matter of an appropriations restriction, and Trump asserted the view, which I think is quite wrong, that because he has a responsibility to faithfully execute the law, that overrides the appropriations limitations. So that's one example. It's probably only a matter of time before we see more. Warn everybody out. Okay, well, if there's nothing else, we can take a break. I think the next panel is at 10, which will give us a few minutes. But thanks again to all of you for being here, for your interest. I'm really looking forward to the rest of the discussion over the course of the day. So thanks again.
So we're going to go ahead and get started with our first panel. But you still have a moment or two to grab some snacks or a drink if you want, but I'll start the introduction.
Right, exactly.
My name is Dave Owen. I teach environmental law and some other subjects here at Hastings. And I'm going to introduce our panelists in just a moment. But before I do that, I'm going to give a slightly longer than normal introduction, just to give you a little bit of context on the assumption that many of you are either new to the environmental field or are not in it at all. So I wanted to give a little bit of context about how deregulation and environmental law thinking have traditionally intersected before our panelists talk about more present day issues. So the idea of environmental deregulation is really, really old. It's just as old as environmental regulation, and even though that emerged in fairly modern form in the 1970s, we've had environmental fights in this country for much longer than that. But after the emergence of what we now think of as modern environmental law in the 1970s, environmental deregulatory thinking got a lot more sophisticated. A group of think tanks and academics and industry representatives came up with a set of ideas that have really driven the thinking of environmental deregulation ever since, and that were enthusiastically embraced by policymakers both at legislative and executive levels and also in the judiciary. And so I'll briefly just flag a couple of the key ideas that underlay this deregulatory movement. One was a heightened emphasis on property rights, and more specifically, the property rights of people who wanted to develop land or exploit natural resources. And with that emphasis went a heightened emphasis on the Takings Clause of the United States Constitution as a method of protecting those development or extraction rights. A second area of emphasis, which Zach mentioned in his opening talk, was on centralized regulatory review of proposed regulatory decisions. I should say centralized economic review. So in practice, this meant cost-benefit analysis with the Office of Information and Regulatory Affairs, which is a sub-agency within the Office of Management and Budget, as the final arbiter of the review. And cost-benefit analysis, as some later scholars have pointed out, doesn't look on its face to be inherently anti-regulatory. It's quite possible to imagine you could have a cost-benefit analysis that says we should have stricter regulation. But the early proponents of cost-benefit analysis very clearly did see it as a deregulatory strategy. They saw it as a counterweight to more sort of ethically, morally, aesthetically based arguments offered by environmentalists. And they also saw it as a way to counter what they perceived as the tendency of regulatory agencies to prioritize their own primary mission at the expense of other collateral costs. So a third key element of this deregulatory movement was federalism, an emphasis on federalism. And again, it was a particular form of federalism with an emphasis on empowering the states and limiting the federal government. And again, as later scholars have pointed out, that's not necessarily deregulatory. Sometimes you have a state like California that wants to regulate more aggressively than the feds. But for the most part, in these federalism debates, the advocates of state power have seen that partly as a method of limiting the regulatory reach of the federal government and the size of the administrative state. So federalism and deregulation have been very, very closely linked. Fourth is an emphasis on separation of powers, and then more specifically on standing, and related doctrines like mootness and ripeness. And advocates of a more robust version of these doctrines, or more restrictive, depending on your perspective, like Justice Scalia, were very explicit about saying that a robust standing doctrine was a way of keeping environmental advocates from going to court and suing private parties or suing agencies to compel them to implement the law. That was a very explicit goal of their emphasis on these doctrines. And then the last element of this movement sort of fits and sort of does not. It's an emphasis on incentive-based regulatory strategies rather than what is often pejoratively referred to as command and control. And for some of their advocates, incentive-based regulatory strategies, and by this I mean things like cap-and-trade systems, and perhaps also taxes like carbon taxes. For some advocates, these were perceived as ways of shrinking government and giving regulated entities, greater freedom. Other people have said, no, this is just another way of regulating. It's not really a deregulatory strategy at all. So there are lots of other elements to the deregulatory movement in environmental law, but these I think are the most important ones. And they have really, to an extent that's hard to appreciate unless you're in the field, they really have defined the debates that we academics and that also policymakers within the environmental realm have. So a huge percentage, I can't give you an exact number, but a very large percentage of the work that we do and that all of us on this panel have done is in reaction to these debates, either trying to advance certain positions with them or channel them or respond to them. And sometimes it's saying these positions are not correct. Sometimes, as some of our panelists have done, it's to say, we really should be debating something else, or we should be looking at different actors. But even when we do that, it's often with explicit reference back to these debates, which really, I think, define the battlegrounds of our field. So with that background, now let me introduce the panelists and talk just briefly about where they fit into these debates. So first off, speaking first will be Dan Farber, who is a professor at UC Berkeley across the Bay. Dan has participated in, I think, every legal debate that there is in legal academia, but he's been a really important participant on a number of the debates that I just talked about. And today, again, he's going to be talking about some of the ways in which traditional administrative law doctrines might continue to constrain some of the deregulatory efforts of the Trump administration. Next up in order speaking will be Jodi Short. And Jodi also is both a participant in these traditional debates and then also a debate expander. She's somebody who has both written on what she sees as some of the flawed assumptions and methodologies of the proponents of deregulation in environmental spheres, and that's what she's going to talk about today. She's also done a lot of work on the roles of private actors in regulatory systems, which is taking these debates in a somewhat new direction. And then finally, Sarah Light also is very much a debate shifter or a debate expander. Much of her work, and sorry, Sarah is a professor. Jodi is here at Hastings. Sarah is a professor at the Wharton School at the University of Pennsylvania. So Sarah's work has focused on the roles that some fairly unexpected actors have played in regulatory systems. So actors like the United States military, and as she'll be talking about today, private entities. So with that background, I will leave it to the panelists. They will each talk for about 10 minutes. I will have a couple of questions for each of them, and then after everybody has spoken, we'll open up to questions from the audience. Thanks.
Is this on, or do I need to do something?
Start talking.
Okay.
Will tell you.
Is the mic on? Okay, great. The day after the election, when we were all still somewhat in shock about Trump winning, I started to think about implications for environmental law. And my first thought was, well, basically, we've been through this before, both with the early Reagan administration and with the George W. Bush administration. And so we sort of know the moves. That is, environmentalists have sometimes been happy with the administration in power, but when they're unhappy, environmentalists and sympathetic state governments and others have sort of perfected a series of responses, and that's more or less what we're seeing now. Some of this goes a bit deep in the weeds in administrative law, and I'm not really going to have a chance in 10 minutes to unpack everything, but I'm hoping in the Q&A, those of you who are not sort of in the field will jump in, and I'll get a chance to say a little bit more. So you frequently see newspaper headlines that says Trump rolls back Obama rule on such and such. And that's generally misleading, if not wrong. What Trump has done is issue executive orders, but the executive orders themselves do not, with just one or two exceptions, change the rules that Obama's EPA and Interior Department and Department of Energy issued. Instead, those executive orders are prompts to agencies telling them to reconsider those rules. They're really quite unnecessary as prompts because the heads of those agencies are all dedicated to more or less the same deregulatory goals and would undoubtedly do the same thing anyway. But the White House wants to have their imprint on what happens next. Agencies, as I think Trump was somewhat surprised to learn when he took office, can't simply wave a wand and make rules go away. They have to go through a complicated series of procedures in order to change existing regulations. Under the Administrative Procedure Act, they have to make a proposal with an explanation of why they're doing that. They have to receive comments from the public, which means, most importantly, from opponents of what they're trying to do. And then they have to issue their final rule explaining their responses to the objections that have been made during the rulemaking process. That takes time, and it takes more time because the courts have interpreted those requirements to require a very detailed set of disclosures by the agencies of exactly what its reasoning is and what evidence it's planning to rely on. and then very careful attention to conflicting arguments and additional evidence that come out during the notice and comment period. So one result of this is that it often takes a long time to issue a rule. Some of the regulations of the Obama administration that are most controversial were several years in the making. So that introduces a significant delay factor. They then have to persuade a court that they actually considered and gave rational responses to all the objections. Not infrequently, some or part of the rule gets sent back to them for further consideration. Things can go on for a long time. It can be a very slow and frustrating process. People who are in favor of regulation used to complain about the ossification of the regulatory process. However, we now view ossification as our friend. So the Trump administration is not in a great position to engage in at least parts of this process, the parts requiring really detailed, careful analysis of evidence and so forth. And the reason is that all of these agencies, the agency heads, are more or less at war with the staff. And it's the staff that has to do all of the heavy lifting in terms of those detailed responses. In addition, those agency heads are often somewhat at war with the science, which makes it even harder to give a plausible answer. So what they have tended to do in dealing with the big Obama rules, and even some of the minor ones, is to try to avoid getting mired in disputes about the evidence by basing their decisions on one of two things. Either a desire for delay while they think things over, or a change in the legal interpretation of the statute that the agency is applying. So the most important thing that they've probably done so far has actually consisted of delay. They've persuaded courts that were hearing cases involving Obama-era regulations to put them on hold. They have issued orders of one kind or another to delay the implementation or compliance dates of various regulations, et cetera. Some of this has been reversed by the courts, as in the methane example that Zach was talking about. Some of it really hasn't gotten to litigation yet. So that's a delaying strategy, but it doesn't ultimately get rid of the rules. In getting rid of the rules, they've preferred to say that the Obama administration distorted the law and that the correct interpretation of the law does not allow what Obama did or what his EPA did. That is a lot easier to do in terms of the number of staff and the level of expertise needed to do it, as compared with trying to contest the meaning of 20 or 50 scientific studies. And so it's something they can do more quickly. The question then will be, how does that go over with the courts? Under the Chevron doctrine, which used to be incredibly obscure, but now you see in the newspaper from time to time, courts give agencies leeway in interpreting the statutes from Congress that the agencies apply. Conservatives have been increasingly unhappy with Chevron and have called for stricter judicial review. It'll be interesting to see whether they continue to call for stricter judicial review when the issue involves regulations or deregulations that they actually like. And of course, the liberals could switch sides too. It's depending on what's going on in the executive branch. But even under Chevron, there are limits to how far the agency can go. There are some recent cases that suggest that the agency may still need some evidence to back up its arguments in interpreting a statute, but that'll be the next phase that I think we'll see in terms of judicial rulings. So that's the rollback process. There were a couple of other aspects of the administration and there are efforts that I wanted to at least mention. And some of those were things that Zach touched on, but in environmental law, there may or may not be differences. So one is the issue of under-enforcement. One of the things that happened in both the Reagan and Bush administrations was that there were big cutbacks in EPA enforcement efforts. And that is very hard to combat directly. It's very difficult. There's really no way of forcing them to bring enforcement actions. Under the environmental statutes, this is a very unusual feature of environmental laws. I'm not sure that it's found anywhere outside of the environmental field. There is a backstop. The Congress, in passing the major environmental statutes, provided that ordinary citizens, and that also includes environmental groups and state governments, can actually bring enforcement actions on their own. They can't bring criminal actions, but they can bring civil actions to require a polluter to pay penalties. The penalties are paid to the government, but they can also get attorney's fees, which are paid to the group. This has been an important backstop during these periods when federal enforcement has been weak, and I think we can expect to see quite a bit of it in the upcoming periods. As a footnote, I should say that the environmental groups have gotten big surges in membership and financial support since the election, so they actually have been hiring staff pretty quickly. So there is, in the environmental area, something of a backstop, of a safeguard against lack of enforcement. There are limitations on this. Conservative judges may try to expand those limitations, but at least for now, this is a way of countering under-enforcement. Now, regulatory review is something else that I've spent a lot of time thinking about over the years, the role of OIRA, the White House Regulatory Office, in reviewing regulations. I don't think it's significant under the Trump administration. And the reason I don't think it's significant is that OIRA's primary role has been to slow down new regulatory initiatives. There aren't going to be any, or at least very few, and only under coercion from a court. As a result of that, OIRA's primary function of preventing regulations won't really be called into play. In theory, OIRA should be overseeing deregulation, subjecting deregulatory efforts to cost-benefit analysis, which would be a problem for a number of them, in fact. But OIRA seems at present to be more or less defaulting on that and allowing really sort of cursory, not very professional economic analysis from agencies to slide right through as long as it supports the president's agenda. So maybe one of the takeaways here is that cost-benefit analysis is really not a very strong tool for ensuring more objectively validated decision-making. It seems to be, at least in practice, maybe too responsive to the political views of the administration to actually perform a large restraining role in either direction. I think I've probably about used up my 10 minutes, so I'd be happy to answer more questions. I have hours and hours worth of things to say about this, but I do feel I should let my fellow panelists talk, so thank you.
Does this work, Tina? Should I start? Okay, no, I think I'm standing here. All right, so thanks very much, everyone. Thanks for being here.
Thanks for the great framing of this panel, and I will get on with my talk for today, which is not directed towards environmental deregulation specifically, although is highly relevant for environmental deregulation. So one of Donald Trump's first acts in office was to sign Executive Order 13771, titled Reducing Regulation and Controlling Regulatory Costs. Executive Order 13771 has come to be known as the 2-for-1 order because its primary mechanism for achieving its titular goal is to require administrative agencies to repeal 2 regulations for every one they propose to enact. Now, while many have derided this order as silly and irrational, and perhaps I'm suggesting the same with this start to the presentation here, it would be a grave mistake to dismiss 2-for-1 as a one-off political stunt. And here's why. 2-for-1 is embedded in a larger deregulatory project theorizing that the sheer quantity of regulation is causally related to certain macroeconomic outcomes of interest. For instance, declines in US employment, US competitiveness, things of that nature. In a string of studies, researchers have attempted, so far with little success, to establish this relationship by counting regulations in the variety of different ways that you see displayed here and correlating these regulation counts to various macroeconomic outcomes of interest. The intellectual project seeks to provide a body of evidence that could supply a rational basis for deregulatory policies generally, but specifically for deregulatory counting projects like the 2-for-1 order. So my paper questions the empirical validity of the regulation counting project towards 3 ends. The first is to delegitimize this body of poorly conducted and frankly cynical research. The second is to ensure that this kind of research will not be taken seriously as a basis for supporting deregulatory policies like the 2-for-1 order on judicial review. So this is actually circling back to some things that Dan has talked about, right? That when these policies do get reviewed by a court, they have to have some sort of rational evidentiary basis. 2-for-1 standing alone currently lacks that, as I think a lot of people have written about and pointed out. But studies like these that are being called for based on these regulation count databases, my view is that they're seeking to provide what might be seen as a rational basis, and I would like to deprive them of that possibility. And then finally, I'd like to suggest a broader critique of the deregulatory project by revealing that its true foundation lies not in concerns about economic efficiency, but rather lies more in irrational fears and feelings about regulation. Now, while these fears and feelings might be important politically, they might be things that we need to deal with, they do not serve as a rational basis for administrative policies. So with that, so I said the 2-for-1 order is embedded in this longer term constellation of projects that try to empirically tie the amount of regulation to macroeconomic outcomes of interest. So you see here some of the different ways of counting, the pages in the Federal Register, the pages in the CFR, the bit size of digitized statutory codes. The latest incarnation of this project is called RegData. RegData is a database created by scholars at George Mason University at the Mercatus Center. And these scholars claim to have overcome many of the obvious limitations of some of the other methodologies for counting. And so this makes it the current state-of-the-art methodology for counting. They also recently made their database publicly available with a call for research using their regulation counts to establish these kinds of statistical associations. So that's why the RegData database is the focus of my paper and certainly this talk for purposes of today. So let me tell you a little bit more about that database. What counts? How do they count the regulations in the RegData database? Well, what they say is we're going to move beyond just, this scattershot methodology of counting pages or counting the digital size of codes. We're going to count, what's really important is how many regulatory mandates are in the Code of Federal Regulations. So they count regulatory mandates, and they charitably exclude Title 35, which regulates the Panama Canal. And so how do they do this? They use 5 terms that they say are indicative of regulations that are likely to limit choice sets. These are the 5 terms: shall, must, may not, prohibited, required. Okay, so that's how they count. Why do they count? Because as I said before, what they're trying to do with these counts is to create variables that can be used in empirical analyses to assess causal relationships between the number of regulations and economic outcomes like productivity, employment, competitiveness, etc. Now, the problem with that is that these projects violate very fundamental tenets of causal statistical inference. There are certainly a lot of things that contribute to valid statistical inference, as actually many of our non-lawyer friends out there could attest. But at the most basic, causal inference requires measurement validity, meaning you have to have a well-defined construct, and that construct must be validly measured. So what I argue in this paper is that both of these things are lacking in regulation counting projects. First of all, the construct. What is the construct in these regulation studies? It's actually very unclear, and this makes it difficult to draw causal inferences from these studies. So sometimes it's characterized as costs, sometimes it's characterized as burdens, sometimes constraints. All of these things operating on private entities, right? Not an aggregate notion of costs, not an efficiency-based notion of costs, but the notion of costs, burdens, or constraints on regulated entities. I'm not going to talk a lot about this here today. I want to focus on the measures, but suffice it to say that these constructs are not well defined in the research. They're used interchangeably, even though they are not necessarily the same thing, and they're not well theorized. It's certainly not theorized as to why we count them only with respect to regulated entities and not in some aggregate sense. But what really concerns me here today is the measure, how this construct of cost, burden, constraint on regulated entities is measured. And the answer for these studies is by the number of mandatory words in the CFR. What's the trouble with that? Well, there are lots of problems with that. And so I'll go through some of them here. And I guess, what I would love to get feedback on is if there are any that I have missed, and certainly examples. So I've started trying to collect examples from the statutory code of each of the examples that I'm going to, each of the problems that I'm going to talk about here. But I would love to get input from other people if ideas for statutes that kind of illuminate these concepts come to mind. So here we go. The troubles with counting. The first, counting does not account for weight. Obvious, right? If I ask you, how many things do you have in your backpack? If you have 10 feathers in your backpack, that's going to reflect one amount of burden on you as you carry it from here to the BART station. If you have 10 anvils in your backpack, that's going to reflect a very different version of the burden you will carry from here to the BART station, right? Counting does not account for scope. Regulations have a very different scope of coverage. Some regulations apply to many, many, many regulated entities. Some regulations only apply to a tiny slice of the regulated community. These are counted equally in the regulation counting projects. Third, regulation does not account for the object of regulation. Again, the construct is supposed to be costs, burdens, or constraints on regulated entities. It turns out that upwards of thousands of the mandatory constraints contained in the CFR are constraints on government, usually for the benefit and protection of regulated entities. But these are counted in these regulation databases as constraints, burdens, costs on regulated entities. Counting does not account for the source of regulatory requirements. And so here, what I mean by this is that there are many times in which statutory requirements are reproduced verbatim or nearly so in the Code of Federal Regulations, largely for the convenience of regulated entities, so that you can have a coherent picture of all the requirements, everything's in one place. But these are not requirements, mandates, constraints imposed by agencies. they're imposed by Congress. Now, we may be upset about this too, but that's a whole different kind of problem that, that there's no way of dealing with. It's not the agency's fault, basically. These are not agency-created burdens. Counting misconstrues or miscounts conditional benefits as burdens. So there are many goodies that the federal government gives out. Some of them quite valuable, right? A lot in the forms of grant funding, but also things like oil drilling leases offshore, right? So if you want to drill offshore, there are many conditions that you must comply with to receive that lease from the federal government. Of course, if you don't want to do that, you can ignore these mandates entirely. And if you do want to do that, it strikes me as odd to characterize that as a burden when the result of that is you gaining this incredibly valuable asset or benefit. Again, these regulation counting projects count those as burdens. These get into the weeds of statutory language a little bit. Counting does not account for structural and grammatical relationships among regulations. So things like exceptions, right? There are some exceptions that basically swallow the putatively mandatory rule, but those rules are not removed from the count of burdens. Disjunctive alternatives. Many regulations have a list of alternative ways you could comply stated in mandatory terms. You need select only one of them, but they would be counted. Each of those disjunctive alternatives would be counted as a mandate. Sometimes regulations just reference other regulations, saying if you meet the conditions required by some other regulation, then you can do X, Y, and Z. They don't create any new mandates. Many regulations elaborate other regulatory requirements, often to the benefit of, often at the request of regulated entities to make their obligations more clear. Many regulations use mandatory language, but actually negate it right after. Will not be required, for instance, would still, the count would still pick up required and not the not. And finally, punctuation. It actually surprised, I mean, I got down and dirty with the CFR in this project in a way I never really expected, but one of the things that I just hit, lots of regulation, lots of the text of the CFR is phrased in question and answer format. Again, presumably for the benefit of regulated entities to make it clearer, more colloquial. So what this means is that there are question marks after many mandatory terms. And of course, those in these in the reg data database are counted as mandates. And then finally, this one is a little more complicated, but counting does not account for enforcement levels. But I think this is incredibly important. There are sections of the CFR that have never, and to my knowledge, will never be enforced. So for instance, the section of regulations on waste disposal at Yucca Mountain, those are all counted. And of course, we have the issues of enforcement priorities and regulatory forbearance that Zach and many others have been talking about this morning. It's just the dynamic nature of this, and the fact that some regulations just are not enforced for a variety of different reasons. But nonetheless, those mandates are counted just the same as mandates that are vigorously enforced. So, am I out of time? Nearly so. Okay. So, okay, we're very, very close. So, all right. So just two more slides here. So if, as I'm arguing here, regulation counts are not measuring costs, benefits, or constraints on regulated entities, what are they measuring? My suggestion is that they're measuring the psychic burden of regulation. And there has been some talk in the press about this. So a very well-known economist, Robert Shiller, has suggested that individuals who have strong business connections seem to take regulation as a personal affront, as if it stands as a barrier to their self-actualization and personal fulfillment. President Trump has himself made statements that suggest that he believes this theory. He thinks American businesses have been treated very badly. And so there's this kind of emotional freight that comes along with these sorts of initiatives. This is what makes them so politically popular. The problem is, again, getting back to administrative law and whether these could serve as the support for an administrative policy. Well, we would have to ask ourselves an empirical question. What kind of relationship could you theorize between psychic burden and outcomes of interest? Does the psychic burden of regulation bear any relationship to economic outcomes? Maybe, but that's a theoretical project that hasn't been adequately undertaken by those who are suggesting that that is in fact the case. Would reducing regulation counts reduce the psychic burden of regulation? I don't know. These are interesting questions, but it's not the questions that we're testing. So why does it matter? Just very briefly, why not just count for counting's sake? I think that Sesame Street teaches us all that we need to know about this. And we can talk about these, our favorite Sesame Street sketches later. But the two big answers are that counting thwarts purposive means ends rational action. It prevents us from achieving our goals. And it also is incredibly, incredibly wasteful. And so with that, I am going to turn it over. Thanks very much.
Okay, great. Hi. So I want to suggest that today is the only presentation in which you're going to be hearing about Lord Voldemort, and that Donald Trump is not Lord Voldemort in my scenario. So what I want to talk about are administrative Horcruxes. The term Horcrux, familiar to any reader of the Harry Potter series, refers to the external objects into which the villain, Lord Voldemort, placed portions of his soul in order to achieve immortality against the threat of attack. His Harry Potter's teacher explained to him that even if one's body is attacked or destroyed, one still cannot die, for part of the soul remains earthbound and undamaged. So what I want to ask is, we have this question. We're in an age of sort of deregulation, particularly with respect to environmental rules. Is it ever possible to anticipate deregulatory challenges through the use of administrative or regulatory Horcruxes? Essentially, the idea would be to attempt to harden regulation against attack, particularly when that attack is focused on a single primary federal agency like the EPA, which is so very much in the crosshairs at the moment, by fragmenting rules across different institutions within society. And so I very much appreciated Dave's introduction of my research to date as kind of expanding some of the boundaries in environmental law, because if I were to describe it, I would describe my research as being about beyond EPA. And so that's where I want to take the conversation today. So this is kind of an, how do we anticipate deregulation, and are there ways to address it kind of talk. So there are really two questions. The first question is it ever possible for a regulator, and here I'm kind of eliding some important complications in that often there isn't a single regulator who adopts a regulatory program. There's sort of an enacting coalition of interest groups and institutions, but I'm going to call them the regulator for now. So is it ever possible to harden a regulatory program against deregulatory pressure? And second, raise the normative question of, is this actually a good thing? I mean, in the Harry Potter case, Lord Voldemort is the villain. And here I would like the environmental enacting coalitions to be able to kind of put ourselves into the shoes of Lord Voldemort to see what is possible to be done to insulate environmental programs against regulatory attack. So other scholars have looked at ways in which agencies can sort of insulate themselves from presidential control through internal means, or by the design of the agency itself. So you create an independent agency with an independent agency head like the SEC or the Federal Reserve, as opposed to an executive agency like the EPA, where there's a cabinet level secretary. My approach is instead to look outward. There are three different types of Horcruxes in this scenario. The first is a horizontal Horcrux. The horizontal Horcrux says, is there another agency at the federal level that is not EPA or the Department of the Interior, or basically, is there a secondary federal agency whose mission is not primarily to promote environmental protection, that can act either as a co-regulator with EPA as a stand-in for all sort of environmentally primarily focused agencies, or that can act on its own. And I want to talk a little bit at the end of the presentation about the role of the Department of Defense in this regard. The second type of Horcrux is a vertical Horcrux. And so this is the idea that the states or local governments can act as either co-regulators with the federal government or act on their own when the federal government chooses not to act. And then finally, there are private Horcruxes. Now, some might argue that private action is synonymous with deregulation itself, but there's an entire literature about new governance, reflexive law, modular environmental regulation, which explains the ways in which private actors often partner with government actors to adopt rules, be they rules in which the federal government provides incentives for private regulatory targets to go beyond compliance by adopting sort of private certification systems, or alternatively, private entities can adopt forms of private governance or private ordering on their own. And I give as an example something like Walmart's supply chain management. So if Walmart says to its suppliers, you all need to reduce your packaging and you need to disclose your greenhouse gas emissions, or we're not going to buy your stuff, that actually can have a very significant impact from an environmental perspective. So there are vertical, horizontal, and private Horcruxes, and then there are sort of ways to distinguish among Horcruxes depending upon the degree of shared regulatory space that they inhabit with the kind of primary federal agency like EPA. So there are some programs, regulatory programs, in which authority is shared. Think about, for example, the Energy Star program, which is a regulatory program housed both within the EPA and the Department of Energy that certifies your washing machine as being a good performer in the energy, sort of low energy demand space. And then there are programs in which EPA plays no role at all. So this is something like the Department of Defense in what I have called in prior scholarship the military environmental complex. So when can Horcruxes be created? By whom? They can be created at the time that a regulatory program is put into place, like the Energy Star program being created both in these two agencies, or they can be created at a later date. And why? What are some of the advantages? So there are a number of potential advantages to fragmentation. And this is something that exists not just in the kind of political context, right? We live in a world of separation of powers. And part of the reason why we have separation of powers in our Constitution is to ensure that no single branch of government becomes too powerful at the expense of the others. At the same time, when the Department of Defense is thinking about how to ensure that its military installations can continue to train soldiers to be prepared for fighting wars, and is concerned that there may be an attack on the electric power grid, which is in some cases centrally managed, the Department of Defense decides to invest in microgrids or renewable energy that exists at each military installation to ensure that if the centralized grid is attacked, that the installations still have the power that they need. So fragmentation itself can be protective against attack. Second, if there is the need at the time that a regulatory program is adopted to speak in kind of multiple languages, to frame a problem in broader ways than purely about environmental protection, this can promote democratic deliberation. It can it can basically kind of create a broader base of support. So there's an entire empirical literature in the topic of climate communications or framing that demonstrates that while certain segments of the population on the political left find framing climate change as a matter of environmental protection or moral duty, those frames are compelling to that segment of the population. In fact, the conservative side of the spectrum is very much put off by a moral frame or put off by an environmental frame. And the example that I like to give is that some colleagues of mine at Wharton did a study where they were testing consumer willingness to purchase either an incandescent light bulb or a compact fluorescent light bulb. And they were given information about the energy use, demonstrating that the compact fluorescent obviously used less energy and would last longer. And by and large, people on both sides of the political spectrum chose to buy the compact fluorescent light bulb. Then they repeated the experiment by affixing a sticker with the words "protect the environment" on the compact fluorescent light bulb. And what do you think happened? Those who self-identified as more conservative did not buy the compact fluorescent light bulb as frequently, right? So there are framing effects. And so I know that there are probably a number of public health scholars in the room at the moment. So Edward Maybach and others at the Yale Center for Climate Communications have done a lot of research that shows that one frame for climate change that actually spans the political spectrum is a public health frame, talking about the ways in which climate affects public health, right? It's very personal. This could make me sick. This could increase asthma, something like that. That's going to be kind of a more generally accepted frame. So if rather than seeing climate action as something just to be done by the EPA, but if it is seen as something that also protects public health and therefore has a house in a federal agency relating to public health, then maybe that's something that will attract more support and be less likely to be destroyed. Now, on the other hand, there are disadvantages to this approach. Again, Lord Voldemort is the bad guy, right? So the idea of his immortality is not good. So there's a risk that this approach may be somewhat anti-democratic, right? The idea that it makes it harder for a new administration to overturn or end a regulatory program seems like it raises the anti-democratic problems that administrative law and the law of, and just agency action does in general. And the other challenge is that as the center weakens and a program becomes more fragmented, it is quite likely that the regulatory program cannot accomplish quite as much as a centralized program can. And so this is why, in many cases, state action has been considered to be deregulatory. I see it as a potentially incredibly important backstop when we have a federal government that's not interested in enforcing environmental law. But at the same time, the states obviously cannot adequately address interstate spillovers the way that the federal government can. So a regulatory program about the climate may remain in 19 states that has a very important impact as a Horcrux, but it's not going to have the same impact that the program is going to have at the central level. Do I have a couple more minutes? 2 more? Okay, 2 more minutes. So I just want to talk a little bit about the Department of Defense. And the reason why is because, so it's very obvious that we have a head of the EPA who does not believe that climate change is a human-induced problem, but the Secretary of Defense does. And when Jim Mattis was a commander in Afghanistan back in 2004, he basically said, look, the military needs to be unleashed from the tether of fuel. Why? Because if you are fighting a war and you need to get fuel to the front lines, those fuel trucks have to be guarded by soldiers, and that is an easy target, and thousands of people died guarding these fuel trucks. Same thing, if you are on the front lines or at a forward operating base, you need sources of fuel to run your HVAC systems in your tents and to create the power that you need. And a lot of that is being done by diesel generators, which are smelly and environmentally harmful, but worst of all for the soldier, loud, right? You don't want to have a big footprint. And so the ability to replace some of that technology with things like solar chargers, solar blankets that the military, particularly the Marine Corps, is very interested in exploring and testing, to be able to reduce the number of batteries that soldiers need to carry into the field through the use of better battery technology. These things really matter. And so while we see the loss of language about climate change in the EPA context, it is still in the Department of Defense. It's on the website, it's in their programs. The Department of Defense has a mandate from Congress to generate or procure 25% of its installation energy by 2025 from renewable sources. And so each of the three branches of the military has interpreted this to mean generating 1 gigawatt of renewable power. And so they are building solar arrays. And this has tremendous potential for spillover effects into the private sector by helping to reduce the cost, by helping to drive the creation of technology. So I think it's very important to be thinking about what is happening beyond EPA and not to get totally depressed, but rather to see hopeful signs in those other institutions. Thank you.
So I'm going to start with one question for our panelists, and then I'll turn it over to the audience. The one question is actually a two-part question, though. And that question is, first off, Dan, you talked about how we're seeing an old playbook trotted out again, and we all agree, I think, that that is true. Are there new plays, significant new plays that we are seeing? So that's part one. And then part two is, I think most people who are critics of the ideas of environmental deregulation, and I think that includes all of us on this panel, would still concede that deregulation has, in some instances, actually been a good thing. And so I'm wondering if you're seeing anything new in the current era, even if it's just a hint of something, that we might look back on in 20 years and think, well, that actually was a good idea, even if we didn't like most of what was taking place.
The second one is really hard. In terms of what we're seeing that's new, I think that the main thing that I would point to is the willingness of environmentalists to invoke, and other opponents of deregulation, to invoke cost-benefit analysis, which historically has been seen by not everybody on the pro-regulation side. There are some notable exceptions, but by probably the large majority as a really bad thing that we would like to get rid of. And as it turns out, a number of the Trump administration actions are really pretty hard to justify based on sort of straightforward cost-benefit analysis. For example, the repeal of the Clean Power Plan, that's Obama's biggest climate change regulation, is actually really hard to justify in cost-benefit terms. And if you look at what the agency did to get there, they had to, and try to justify what they were planning to do, they had to really contort themselves to try to explain away a lot of potential benefits, including major health benefits, because the spillover effect of reducing greenhouse gas emissions is generally to reduce conventional air pollution, especially from coal, which is a big public health problem. So I think that that's something that's new and is maybe a case of people retroactively deciding that maybe there was something to what they previously viewed as a deregulatory effort. I would have to think long and hard beyond that. I think arguably, partly it depends on your policy views a little bit. I mean, even within the sort of general constellation of people who are favorable toward environmental law, there's sort of a division of views about nuclear power, and with the conventional environmentalist view being wholly opposed, but with some reconsideration of that because it's zero carbon. And to some extent, there's a division of views about things like fracking, because to the extent natural gas replaces coal, that's good for climate change and also good for local air pollution. So it's possible, especially if, I would guess maybe more with nuclear, that if some of the problems with nuclear power are addressed in a convincing way down the road, which is a big if, we might think, yes, it was a good thing that they loosened the brakes on that. But I'm kind of stretching to be responsive to the question, because I would say nearly all of it is just characterized by just not very well-informed deregulation. That is, not replacing things, for example, with market mechanisms to achieve the same goals, which is something that, say, the Bush administration tried to do, or trying to find other ways of addressing problems, but basically just denying that problems exist in a way that I think it just doesn't lead anywhere good.
You're both welcome to answer if you'd like.
I think I'll leave it there.
Okay.
I'm not sure that I have anything to add.
Okay. Questions from the audience? Yes.
It seems to me ironic that the conservatives have taken the mantle of being anti-conservancy of the environment. And if you go back in American history, there was a time, I think in the 19th century, when the Republicans were the more liberal spectrum of politics, and the Democrats were conservative. And in that time, the Democrats were actually the champions of more conservative policy toward the environment. And I think in 1862, the New Republicans under Lincoln championed the Homestead Act. And that was a liberalization of a preemptive act that allowed settlers to take land in Nebraska and Kansas. And that act was opposed by conservative Democrats at that time. It seems to me more congruous for the Liberal Party to champion liberalization of the environment and the Conservative Party conservancy. Does that make sense? So how or why when did the conservative way of politics, whether they call Democrats or Republicans, start to become liberal, liberalizing regulation toward anti-conservancy of the environment?
Well, Dan has actually written an article about this,
Yes.
so I'm going to defer to Dan.
And I did not plant that question. So actually, I just published an article on conservative environmentalism. And I think that change happened more recently than one might think. If you look at the environmental laws that were passed in the 1970s, most of them were passed by overwhelming bipartisan margins. Richard Nixon took the initiative in a number of, now he had complicated reasons, not all of them good, but he took the initiative in a number of environmental actions like establishing the EPA. I did some historical research, and it turns out that if you look at even the 1970s and up to the early 80s at least, you find surprising support for environmental protection from people like Ronald Reagan, who has been called it's disputable, but it's not a joke, possibly the most environmental governor California has had. Barry Goldwater published a book in '68 or so with a chapter, half of which is about the need to take really stringent action immediately to protect the planet, even if it hurt the economy. Even William F. Buckley, when he was running for mayor of New York in the, I guess, late '60s, called for shutting down coal power plants and banning cars and all kinds of really strict environmental measures. That changed really in the 1980s, not as quickly as some people think. Reagan actually did some pro-environmental things in office, and not just things that were forced on him. But I think and even under George H.W. Bush, there were some important environmental advances. So I think it's really been kind of a long transition. As recently as 2008, McCain favored cap and trade to deal with carbon emissions. But what we've seen is over that time, a general trend toward more and more adamant opposition to any type of environmental protection. And I have some theories about why that took place that are probably not worth going into now. But I don't think it's inherently, I agree with you, I don't see any reason why it's inherent in conservative ideas to be against protecting the environment. And there are some interesting sort of dissenting voices within the conservative movement today that I'm hoping will sort of take root.
May I jump in on that as well? So a few months ago, I heard a really wonderful talk by a person who works in Georgia on the issue of rooftop solar distributed generation. So the idea behind distributed generation is that many people can install solar panels on their roofs and then interconnect to the power grid to provide electricity that replaces some of the fossil fuel powered electricity generation. The challenge, of course, is that a number of state laws expressly prohibit this or make it uncertain as to whether this is legally permitted. And so in order to attempt to change the law in his state, he originally tried getting support for an environmental bill, rooftop solar, this is going to be good for the environment and good for the climate. Not a lot of support. So instead, what he decided to do was talk about this as a property rights issue. And he founded a PAC, and the PAC was called the Property Rights, the Homeowner Property Rights Association. And the tagline for this bill was basically, the government can tell me what to do on my house's roof. I should have a right to put solar panels up if I want to. And the bill ended up passing with almost unanimous support. So it's interesting that in Dave's kind of framing for the panel, the first thing that you mentioned about the deregulatory kind of themes was that private property rights are often asserted as a basis for deregulation. And that certainly has been true under the Endangered Species Act and in other cases. But I think just in the same way that there's been a shift in the conservative relationship to the environment, there needs to be a shift in the more liberal relationship to the environment, and to think about how to frame these problems in a way that's going to resonate with a broader segment of the nation.
If I could just jump in again, that's really interesting. I'd like to know more about that. But another sort of conservative idea that is important in some areas are free markets. So Rick Perry has made a proposal it's kind of complicated, but the upshot is that electricity prices would include what amounts to a subsidy to keep coal plants and nuclear plants open. And that has sparked reaction from some of the people you would expect on the liberal side of things, but also from conservatives who view it as interfering with the free market. And how do you justify that? And interestingly, going back to another one of Sarah's themes, one of the important groups opposing this is the American Petroleum Institute, because they think it will hurt their natural gas sales. So the way these things shake out is not always just on sort of the predictable dimensions, and I think that's really a good thing.
Other questions?
This is kind of a combination comment and question. I was really interested, Sarah, when you were talking about the EPA. And you're right, there's essentially one administrative agency that takes care of those regulations. Now, for those of us in the financial world, we can't keep track of the number of administrative agencies that are overlooking the financial landscape. And so I guess this is the common question. Does that then better protect regulations in our sphere of the world because you sort of have more agencies to deal with? A lot of people in our sort of the world are often advocating for more consolidation of regulatory agencies because of cost. So I was just wondering how you compare
Right. So, so to some extent, when I say EPA, I mean, obviously EPA is the primary environmental regulator, but there are other agencies that play a very important role. So the Department of the Interior, as a, land management and resource agency with many of its sub-agencies, or the Department of Commerce with sub-agencies like Fish and Wildlife or NOAA, or the Bureau of Land Management. So there are multiple entities, and the Department of Energy in some sense, although it's really about maintaining the nuclear stockpile. So there are multiple environmental agencies, although the way that we all learn what environmental law is in a standard anti-pollution environmental law class very much focuses on the statutes that have agents, the EPA is the primary regulator. So it's a little bit more fragmented than just EPA. That's a little bit of a shorthand, but I have not done a comparison. And I mean, some of what I'm suggesting in the talk and in a paper that I've written that's the basis for the talk is that there's a lot more empirical research that's needed in this area to determine which types of fragmentation, first of all, do they actually increase durability? Which types of fragmentation are more durable? And then I think that there's a whole host of comparative questions, not just in the environmental space, but in the financial space and in other areas. I mean, I think it's very interesting. So just to give one example, under the Congressional Review Act, which is the statute that allows for the essentially the Congress and the president to jointly repeal a regulation that was passed at the very end of president's term, there were, I believe, 3 environmental regulations that were nixed. One of them was an SEC regulation requiring fossil fuel firms to disclose any payments made to foreign governments. Firms that are in the business of resource extraction had to disclose payments made to foreign governments, which was a kind of anti-corruption environmental provision housed in the SEC. And that was gone. So, it's an open question empirically whether these types of Horcruxes are in fact more durable and what makes them more durable.
Yes.
So when you see within the current it sounds like, would it be easier for them to, for the staff to put these regulations with consumer terms and people going to be threatened by the thought of regulatory burden instead of looking at it as a positive impact on the consumers? Right now, you're fighting on something that overrides regulations because of this discussion.
I think there have been a lot of efforts to do just what you say, to make regulatory requirements accessible to average people. I don't think that helps, honestly. And I think it's partly because we haven't been dealing with the issue head on. We've been disguising it as, well, the problem with regulation is a problem that cost-benefit analysis could solve. If only we could make regulations more efficient, and that would solve the problem. I think we've been lying to ourselves about what many people see as the real problem with regulation. And I don't think that has served anyone over time. How do we actually deal with it? How do we have an honest conversation? I don't know. Do we get everybody therapy instead of repealing regulations? I don't know. That seems unrealistic, but I guess I want to push for more of a recognition about maybe what's really driving some of these things, because I suspect it's not a concern about efficiency and costs and things like that.
It's interesting. I think it's understandable why the people who are directly subject to regulations don't like them. I mean, I'm subject to just an incredible number of University of California rules, and I don't like that. So I can understand why other people who are subject to regulations don't like it either. But what's interesting is the extent to which people who are not, who are beneficiaries of regulations rather than being subject to them have kind of, acquired this anti-regulation, this regulatory aversion. And that's a little harder to understand, I think.
Well, I mean, there is some sociological research kind of documenting how in many areas the state, for a variety of different political reasons, has stepped back, has kind of disowned what regulation accomplishes. And so in many ways, there's not been a story out there. There's been this anti-regulation narrative out there, but there hasn't really been a very robust narrative explaining what the state does for what regulation does. And so that's I think maybe a piece of the story.
Question, I think mostly for Professor Light, but if others have thoughts too. So my field is public health, and in public health, we do a lot of hand-wringing about framing and how to communicate with the public about a variety of different issues. Yeah, it's kind of generally there's support for public health, but when you're talking about any specific regulation, it usually gets characterized as nanny-state, government overreach, and so forth. And so there's a lot of push in the public health sphere to think about different ways to frame those issues as, it's about public health, but it's really about improving the economy, or it's really about national security, or other ways of framing some of those issues. My role in some of those debates has been to push back on that, because those might be good ways of winning some debates in the short term, but at the expense of diminishing the field and the importance of the field of public health in the long term. And I wonder if there's sort of similar discussion in the environmental context of some of the trade-offs of framing things differently.
Sure. I definitely think that there is discussion of that. I mean, going back to the debates about whether market instruments like taxes or cap and trade should be part of the environmental regulatory toolkit, there is a discussion about whether a tax is essentially or an emissions allowance means you're allowed to pollute. Like, where's the hammer that says this is bad? And so there was a perception, even if the outcome would be the same or better, that market leveraging instruments were inferior from the expressive point of view, right? They're failing to express condemnation. In terms of the framing of climate change now, I think that there is kind of increasing awareness of the idea that framing climate change or something else as a purely environmental issue does have these potential boomerang effects. The challenge, of course, is what to do about it. So you might learn that particular frames resonate with people, but it's very hard to change people's views, because one recent study sort of demonstrated that there is just simply so much background information in the press about, doubting climate science, that even if you're able to kind of get some minimal change in a conservative viewpoint about human-induced climate change, that often the effects can be wiped out by any kind of statement or expression of uncertainty. So it's a little bit unclear how possible it is to change people's minds, but to the extent that certain values matter already or inherently, then it may be more compelling.
And with that, we are out of time.